Thank you, everyone, for joining us for our second annual Pennsylvania Farm Show Ag Law Symposium. The symposium, as with last year, will be 4 hours in total length, conducted over 2 days. So we will have 2 hours today, and then 2 hours on Thursday afternoon. The program this year, we are covering a lot of different developments, and we thought the best way to organize these developments would be to organize them somewhat thematically, so that we can cover as many different topics as possible. And so our first hour today will be kind of covering the waterfront with a lot of major legal developments from the past year. And because there are a number of issues that either are before the Supreme Court, before the Supreme Court, or there are requests before the Supreme Court, we thought it would be helpful just to take a look at those specific items and talk about impacts if the Supreme Court accepts the case, or if the Supreme Court does not agree to hear that case. The second hour today, we'll be focusing on two issues, very timely issues related to agricultural markets. The first topic is geographic indicators or indications, which is a very big topic in international trade in the dairy industry. And then the second part of that second hour will be focused on antitrust litigation and enforcement, which again is a very timely topic. On Thursday, the first hour, we will focus on three topics that initially may appear to be somewhat disparate, but they're really all focused on ways that farmers today either have the ability to diversify their income or the potential for that income diversification. So we'll be looking at agritourism immunity, as well as carbon contracts and solar development. And then our fourth hour, our second hour on Thursday, will focus on environmental issues and look at three topics with some pesticide issues, the Chesapeake Bay, and then the ever-present waters of the United States. So just some logistics as we get started today. This webinar is being recorded, and we will make the recording available shortly after the program is finished on Thursday on the center's YouTube channel. Also, the materials, so all of the PowerPoints and other materials for today will be posted on our website on the events page. If you go to the PA Farm Show page on our website, you can locate all of those documents. Now, during the sessions, if you have questions, we would encourage you to use the Q&A tab. We will attempt to address all of those questions at the conclusion of each session. Attorneys, if attorneys who are looking for CLE credits, the form will be on it'll be on our website. It will also be posted in the chat box. Now, in past years, last year we had a separate CLE form for each day. This year, we just have one form. So if you're planning to attend both days, you can wait until Thursday to submit that form. Now, as a way of monitoring attendance that we are required to do by the CLE board, we will be providing a code word. So we'll give you a code word each hour that you have to put on your CLE form. If you have any questions about that, please email Jackie Schweikler, and just if you have any questions about that form. Okay. I want to take special time to thank our partner, the National Agricultural Center at the University of Arkansas. We do a lot of work with them, and this program is provided in part based on our partnership with them through support from the National Agricultural Library. Now, we are pleased this year to have a welcome from Secretary Redding. Secretary Redding provided a welcome last year as well. So I'll turn it over to Secretary Redding.
Welcome to the second annual Pennsylvania Farm Show Agricultural Law Symposium, hosted by the Penn State Center for Agricultural and Shale Law. The center is a critical partner of the PA Department of Agriculture in our mission to help support and grow the ag and food industry, but also in protection of public health and safety. As we've learned through COVID, what we thought we knew about the agriculture industry and the food system has changed. There are many more expectations on the industry than we ever had before. It's more complicated, and as we've learned, it's interwoven in our society. In addition to the economic value, agriculture is at the center of some of the most pressing issues of our time. Climate change, social and environmental justice, food security and access, and make your list. And each of those require the legal community to play a pivotal role in our response, our planning, and the vision for the future. You provide invaluable counsel to our farm families, the agribusiness community, as they navigate the transitions, expansion, sales, trademarking, and the complexities of relationships and agreements and contracts. There's not a farm in Pennsylvania that's not in transition, whether they're aware of it or not. Whether those conversations are held around the kitchen table or a boardroom table, the services of our legal community and the partners that they have to provide that support and resources and information is really critical. Pennsylvania can be proud of many things: leading the nation in preserved farms, having the only state-level farm bill in the nation, leading in sales across many commodities, number one in the U.S. for the number of new farmers under the age of 35. And those accomplishments are simply not possible without your efforts. As you participate in this symposium and hopefully enjoy some of the 106th Pennsylvania Farm Show, I hope you reflect with great pride on the work that you do, the partnership that we have, and that you see the work mirrored across the 8 days of the largest indoor agricultural show in the nation. I'll end where I began, with a simple thank you. Appreciate what you do, appreciate the partnership, and I look forward to 2022. Thank you.
Okay, thank you, Secretary Redding. And so now I'll move on to talking about legal development, some of the major legal developments from the past year. So throughout the other three sessions, we will also be, the presenters will be talking about legal developments that are relevant to their particular topic. So I'm going to cover. I guess I'll first say what I'm not covering, because these are the topics on your screen that will be covered in later sessions, and I mentioned those topics earlier in the introduction. So what I am going to cover are kind of the major developments within these substantive areas, as well as maybe some things that you haven't seen yet. So we'll talk about animal welfare or confinement issues, right to farm, meat labeling, or I guess I should maybe put meat in quotes there, exactly what is meat, biotechnology, talk about a couple developments there, agricultural labor, dairy, and then a handful of other state issues from other states that I think are important to mention. Okay, so the animal welfare. I mean, cage-free laws for the past few years. There are a number at the state level, been a number of states that have enacted laws that are mandating that egg layers be not kept in cages. Obviously, there's a lot of retail-driven efforts in this area as well. But in terms of states imposing requirements, last year Utah enacted legislation that in 2025 would require that the eggs be in a cage-free system, or have a certain amount of space. Kind of fairly typical exceptions in that statute. as well. And there is a requirement that there be a report with by the end of, or by November of next year, that that talks about the compliance, or just kind of looks at some of those issues. Now, in addition to Utah, Nevada also enacted legislation, and their phase-in is kind of two-part, in that by the middle of this year, there's a certain amount of space that that the chickens, that the laying hens that are in confinement have to have a certain amount of space. And then by 2024, the cage-free requirement kicks in. So with Utah and Nevada enacting these requirements, I think that brings us up to 9 states that have requirements. And here on the screen, you can see the other states, as well as the phase-in date. So we have California, that had a phase-in date of last year. Massachusetts has a phase-in date of this year, and then you can see the other states are within the next few years. Geographically, I mean, these states are fairly fairly dispersed. I mean, we have New England states, we have states in the West. Michigan is kind of there in the Midwest. So these state level cage-free egg laws continue to be enacted. In the second part of this first hour, Brook Duer is going to talk about California's Proposition 12, because that certainly is where a lot of the focus has been, just because they're first, and also because California is such a huge state that the impact of the requirements in California are being felt across the country, as it applies to not just hens or eggs that are from California, but it applies to any eggs that are sold in the state. And as you look at all of these other states, the requirements are on eggs that are sold in the state, not just on eggs that are produced in that state. So it has a much bigger impact because of its effect on producers that are raising those eggs in other states. Okay, in addition to the United States, this is also an issue in the European Union. And there was a consumer-led, or a citizens initiative called End the Cage Age. And that spurred the European Parliament to act. And last year, they passed a resolution that requested that the European Commission propose revisions focused on the eventual phasing out of cages. The European Commission then in June of last year jumped ahead. They did announce a communication, and they're committing that by the end of next year they would propose legislation. So it's very much kind of at the early part of that process, but they're moving towards an elimination of cages. Now you can see that the species that are involved. So it includes the hens, sows, calves, as well as a number of other species. Now these last 2 bullet points, I think, highlight something that really are going to have an impact on the U.S. if this moves forward in the European Union. And you can see that in the European Commission's communication, they talked about being an importer, and they talked about considering imposing standards that would require imports to be equivalent to the EU's. So we could have some trade issues with any of these products. So I mean, it's in addition to the developments that are taking place in the U.S., I think this is something that bears watching. Now, the final point on the animal welfare topic. This is a ballot initiative issue where it didn't actually make it to the ballot initiative. And this was in Colorado, where the proposed initiative would have focused on artificial insemination. It would have made the artificial insemination of livestock to be a class 1 misdemeanor. Now, the Supreme Court removed that or struck down that for really a completely unrelated reason, not related to the substance of that, but that this particular initiative focused on two subjects, which violated the requirements. And I raised this just to highlight 2 points. One, that with some state laws, these ballot initiatives really are a way that laws get enacted, and with California, we've seen that in the area of animal welfare. The second point is that all of the focus, or most of the focus recently, has been on animal confinement, but here we have an initiative that was focused on artificial insemination. So I think as these ballot initiatives are successful in enacting laws, I think we have to, it bears watching just what are the other issues that are going to be raised through ballot initiatives. Okay, moving on to right to farm. Now, over the past several years, North Carolina has really been kind of the focus of right to farm issues with these ag nuisance issues, and with a lot of lawsuits filed against Smithfield by individuals who resided close to swine operations. And there were very large awards that were granted to those neighbors who filed suit against Smithfield. Since that time, North Carolina has amended its right to farm law, and the amendment, or the amended right to farm law, so has been challenged through litigation. So the amendment is focused on addressing the issues that allowed for those suits to proceed, and basically adding requirements to address those issues in the future. This was challenged, and just at the end of 2021, the challenge had been dismissed. The North Carolina Court of Appeals upheld that dismissal. So those amendments to the North Carolina's right to farm law stand. Also, Florida amended its right to farm law, really to strengthen it, to further restrict the nuisance actions, to include requirements that proximity requirements. So the plaintiffs have to be within a half a mile, and they have to demonstrate that the farm is violating law or not utilizing best management practices. And then finally, this right to farm law it addresses agritourism activities as well. Okay, the meat labeling. Last year we talked about Oklahoma's meat labeling law, and you can see here in the first sub bullet kind of relevant language that it's a misrepresentation if a product that's not derived from harvested production livestock is labeled as meat. So this is primarily focused on the plant-based meat products, and this was challenged by a company that sells those products. The company was using burger, bacon, chorizo, hot dogs, a lot of pretty common terms, and they were challenging the law because they wanted to use those terms for their plant-based product. They were not successful. Their complaint was dismissed. They appealed this to the U.S. Court of Appeals for the 10th Circuit. They later withdrew that appeal, but now that litigation was filed again, and that first challenge was filed based on First Amendment grounds, based on speech, a freedom of speech. This most recent suit that has been filed is not raising First Amendment claims. It's raising dormant commerce clause and supremacy clause challenges. So So this Oklahoma's law is still being challenged. Now, shifting to the federal government, shifting a little bit from laws that are largely focused on plant-based products to cell cultured meat or cell cultured products. USDA last fall posted an advance notice of proposed rulemaking. FSIS is looking for comments, at the very early part of likely at the very early part of the rulemaking process, focused on just what should they do in terms of imposing requirements on labeling for cell cultured products. And just that you can see here in what they're looking for is they're looking for nomenclature. So that's been kind of one of the tricky things with these topics is what do we call it? If it is it meat, is it something meat, or is there some other term that we're going to use? The comment period closed in November of last year, so we'll kind of wait and see what FSIS does for their next step here. Okay, with biotechnology, there are two topics that I want to address. The first is the Arctic apple, and USDA's APHIS in September of last year announced that the Arctic gala is deregulated, and these Arctic apples are genetically engineered to avoid browning. So for apple slices in the food service industry, there is an advantage because you don't, when you cut the apple, it doesn't brown. And so this Arctic Gala, it joins the Arctic Golden and the Arctic Granny, and you can see both of those products you can buy. Both of those products. You can go to the website for the company to get more information. The reason that I think this Arctic apple is interesting is because most of the genetically engineered products that are in commerce really are focused on the input traits. So they the Roundup Ready, the BT genes, they make production, or they're focused on the production. The benefits are to the production, and so the consumers, I think, are less likely to see those benefits. With the Arctic apple, I mean, this is an output trait. It's focused on making an apple that's going to be different for consumers, that has a trait that is going to be advantageous for consumers. So it will be interesting to see if some of those consumer objections to genetically engineered products, if we will see those with this product or these products that have the output traits on them. The second biotech development that I wanted to discuss relates to genetically engineered salmon, and this again is I guess it's an input trait because this is a salmon that's been genetically engineered to grow more quickly, so that it can be raised in facilities. And this salmon, or the company that raises this salmon, it's been a long process of development and getting the regulatory approvals, and it finally produced its first harvest and first sold the first product from its Indiana facility. So on our website, on our agricultural law issue tracker for genetically modified salmon, we have extensive information on that litigation, and there have been developments related to litigation over the past year as well. Okay, agricultural labor. I want to highlight a couple issues at the state level, and then a couple issues at the federal level as well. In 2019, New York State enacted a Farm Laborers Fair Practices Act, and it had a number of requirements, including overtime pay for agricultural workers. It also provided collective bargaining rights to agricultural workers. And in 2021, that particular provision was first utilized, that there was a group of agricultural workers have unionized, and so it's 12 workers from a vineyard in New York have unionized. So I think that's notable, just to see that is occurring across the border. Also, with regard to heat safety, Oregon and Washington both have their state level agencies both have promulgated rules dealing with heat stress prevention. You can see they're somewhat different in that Oregon requires certain services to be provided to workers if it's at least 80 degrees. If it's 90 degrees, then there are certain breaks that must be provided. Washington State has basically those same requirements, but the temperature threshold is a little bit higher before they kick in. Now at the federal level, OSHA is looking at those same issues. They in October, OSHA issued an advance notice of proposed rulemaking. So again, they're kind of at the early part of that regulatory process, looking at the issue of worker safety and heat injury, and that comment period just ended at about the end of last year. Okay, swine slaughter line speed, and then I'll talk briefly about the poultry slaughter line speed rule as well. So in 2019, USDA promulgated the modernization of the swine slaughter inspection rule, which eliminated some of the plant line speed controls that was litigated. And in March of last year, the district court in Minnesota issued an order that vacated the elimination of those line speed requirements. Now, there was some pressure on USDA to appeal that elimination. USDA chose not to do so, and in May of last year, FSIS basically told the regulated facilities that they needed to revert to that maximum line speed, that the elimination of those controls had been reinstated. Now, with regard to poultry, the rulemaking on that issue was not as far along. FSIS had issued in 2020 had issued a notice of proposed rulemaking. That proposed rule would have established requirements. So, or that proposed rule has been withdrawn by FSIS. So basically, both of those rules are off the table now. To talk a little bit about dairy in Pennsylvania, talk about two items: one piece of legislation, one regulatory action. On May 12th of last year, the Milk Marketing Board submitted to our kind of the Pennsylvania agency that regulations flow through, and the Milk Marketing Board proposed amending the notice that dairy producers get when a milk dealer is terminating their agreement. That notice requirement had been 28 days. With this change, it was increased to 90 days. And so this regulatory change was approved by IRC. So now, when a milk dealer is terminating a milk producer's contract, they must give at least 90 days. The piece of legislation that I want to highlight deals with the milk sell-by date. So the milk has that date of 70 days after pasteurization, but producers can use for either a sell-by, or they can use a best by date. Also, they can apply to the Pennsylvania Department of Ag, and providing they comply with certain requirements, they can actually increase that. So the milk can list a date that is greater than 17 days, which is the standard that has the kind of the general standard. Okay, I want to highlight that if you're interested in learning about developments related to dairy on a regular basis, every quarter we have a webinar that reviews developments nationally and internationally, and then also picks a particular topic of interest to address. And so our next webinar is February 15th, and that will again review the dairy legal developments for October, November, and December of 2021, and also address the dairy industry carbon reduction programs. Okay, so now I just have 3 more state level developments that I think are interesting. The first of these is New York's Environmental Rights Amendment. This was approved by voters in New York in November at the election. Pennsylvania's Environmental Rights Amendment has received a lot of attention over the last few years, and Pennsylvania was somewhat unique in having that requirement. Well, New York has added that. So you can see the language. Each person shall have a right to clean air and water and a healthy environment. So somewhat similar to the to Pennsylvania's requirement. So it'll be interesting to see what that kind of how that is implemented in New York, because there certainly has been a lot of activity in Pennsylvania, kind of trying to, over the last few years, trying to kind of assess exactly what our environmental rights amendment means, how that's going to, how its application is going to work. Second item I wanted to talk about here is also from a ballot initiative in Maine. And this ballot initiative provided a constitutional right to food. And if you look at the language of that constitutional right, that all individuals have a natural, inherent, and unalienable right to food, including the right to save and exchange seeds. So, that's interesting that it has included that seed saving. Also the right to raise, grow, harvest, produce, and consume the food of their own choosing. So, you can look at this, and it could have a lot of potential ways that it could apply. I believe Maine is the first state to have kind of this type of constitutional right, and so it bears watching just to see what happens in Maine with this, and to see if this kind of spreads, if there are other states that kind of look at this and look at having a constitutional right as the way to address this issue. And the final item I want to mention, Secretary Redding referenced Pennsylvania's Farm Bill. Well, it looks like it kind of may be catching on that West Virginia has this past year also enacted a West Virginia Farm Bill, and similar to what's often referred to as Pennsylvania Farm Bill. I mean, West Virginia provides it's a vehicle to provide funding, as well as have some additional provisions included, and you can see the quote from West Virginia's Agriculture Commissioner that West Virginia is working towards introducing a recurring farm bill similar to what is done at the federal level. So with that concludes my part of the program. I want to give you the code word. And so the code word is year. And just to emphasize again, the code word is year. And so with that, I will turn it over to Brook, who will talk about some of the issues that are pending before the Supreme Court, looking forward to what agricultural law is going to look like in 2022. So Brook, take it away.
Okay, thanks, Ross. I'm going to try to get my screen up here without any mishaps. There we go. All right, so I think you should be seeing my screen. Somebody give me a shout and let me know that's
I don't see your screen, Brooke.
not yet. Okay,
No.
wait a minute. What happened here? Aha.
There we go.
Okay. All right. So let me, I am going to put my camera on. However, I have a tendency to get a unstable connection now and again. So I may end up having to ditch that. So just bear with me. And we will see if that works out. All right. So what I'm going to talk about now and for the remainder of this hour is essentially the Supreme Court docket that we're facing here over the rest of 2022. And I am not one who has paid as much attention, of course, in my previous positions as I do now to the Supreme Court docket, but I find it somewhat amazing how many not just ags impacted, but literally ag-centric, ag-dominated issues are in front of the Supreme Court right now. Maybe this is a fluke. Maybe this is not as fluky as I think it is, but I'm pretty amazed. Give me 1 second. There we go. Okay. Just setting up a better way to advance. Okay, so we have 6 things that I want to try to get through. We'll see if I can get through them all. I'm pretty notorious for slowing down and going off on tangents. First is the OSHA so-called shot or test rule, which is in front of the Supreme Court as we speak. And that applies to all employers of 100 employees or more. And it would apply to ag employees. We'll talk about that in a minute. Next, we'll talk about the Prop 12 Commerce Clause challenge that is in front of the Supreme Court right now. And Ross already sort of clued you in on Prop 12. And next would be the all the glyphosate litigation that's going on, the sort of toxic exposure litigation that's all been consolidated basically in the San Francisco area. It's all being administered out of the U.S. District Court there for most of the country. There has been a verdict that has been brought to the Supreme Court to challenge the permitting the jury to make a finding on a failure to warn products liability theory, saying that should be preempted by the federal FIFRA, the federal statute that requires label approvals and registrations of pesticides. So it's a preemption issue, federal preemption issue on the failure to warn theory under state products liability law. Next, we'll talk about the Sackett case, which is just a sort of an obscure one, but it's one where, apart from all the other things about the waters of the United States, this is one where the plaintiffs in that case are essentially asking that let's dial the clock all the way back to 2006 to the Rapinos case or the Rapanos case, depending on how you say it. And they want that analysis to be revisited and essentially rewritten. And next, there is the case that actually was decided yesterday, and that's number 5 on the list, which is the E15 sales authority. Does the EPA have the authority to allow E15 sales under federal law? And in fact, the answer yesterday was no. So we'll talk about that for a second. And then last, I'll make sure we can hopefully get to the Kansas Ag Gag statute, which is these are all petitions for certiorari. These are all petitions for cert. None of them have been ruled upon yet. I should amend that a little bit. There's the OSHA is a little quirky. It's not actually a petition for a cert. It's just a request for a stay from the Supreme Court. In any event, the Kansas Ag Gag statute, we will attempt to get to that. Okay, let me proceed. All right, so just to recap, what's in front of the Supreme Court right now, and there was in fact reported that there was oral argument last Friday, just a few days ago, on this emergency stay request. And what we have here is OSHA's emergency temporary standard for all employers of 100 or more. And they must either A, require vaccinations for their employees to enter the workforce, and technically, that's in effect as of yesterday. No relation to the Supreme Court hearing argument on Friday. That just happened to be the day when it was to be in effect. And then the alternative an employer can offer, if they go ahead and put it in place, is that employees can enter the workforce if they follow the OSHA prescribed testing protocols for regular testing of that employee who is not vaccinated. As just a little past history, this goes all the way back to last January when there was this executive order right out of the gate from the Biden administration about directing OSHA to essentially consider, should there be an emergency temporary standard requiring workplace vaccination or other types of protection, worker protections because of COVID. And one of the things that was interesting at that time, and it all went forward, of course, and there's quite a saga and a history of that. But one of the things that was interesting was there was a little reference, and it's right in here. There was a little reference in the executive order that started all this that said many things, but one was that OSHA should be considering an emergency temporary standard for mandatory vaccination or some other type of worker protections in the workplace from COVID. It said that USDA, Department of Labor, and Health and Human Services, and the Department of Energy to explore mechanisms to protect workers not protected under OSHA, which this was not terminology used in the executive order, but what that points to is that could have included examination of the so-called small farm exemption to OSHA jurisdiction, which essentially deprives the federal government of any ability to enforce OSHA standards against a farming operation that is less than 10 employees and has no employer-supplied housing. So if you supply any employer-supplied housing, OSHA has you in its net, so to speak. Just doesn't matter, whether you have 10 employees. In other words, you could have 2 employees, but if you had employer-supplied housing, then you are in fact subject to OSHA jurisdiction. And the reason that this is in existence is that there was one of these clauses that said Department of Labor cannot use any appropriated funds from Congress to enforce against small farm operations. So it's not that OSHA doesn't apply technically, it's that there's no ability to spend money to enforce against such operations. Creative, legislative workaround. So in any event, the good story of all this, that did not come to pass. None of this has in any way, shape, or form put in question the small farm exemption from OSHA jurisdiction. So ag employers that never top 100 employees are not in any way impacted by this particular executive order. This is just employers of 100 or more, but that would include ag employers. Okay. Then November 5 was the date when it was finally, after months and months and months, you remember this was January when the executive order came out. November 5 was when the emergency temporary standard was issued, requiring employers of over 100 to have mandatory vaccination or a testing protocol as an alternative to allow unvaccinated people in the workplace. On November 6th, the next day, there were all sorts of petitions filed in all of the various federal circuit courts. The circuit court in Louisiana for the Fifth Circuit actually beat everybody to the punch and immediately stayed it. Then on November 12th, there was a Fifth Circuit affirmation of the stay. So it seemed like this thing was going to be perhaps dead in the water. Under law, these emergency temporary standards can only be in existence for 6 months. On November 16th, the Fifth Circuit in New Orleans was deprived of any further jurisdiction. All of the cases were consolidated together that were filed in 8, and every circuit had at least one case. They were all consolidated, and the Sixth Circuit was assigned by random process to be the decision-making circuit on this issue. Surprisingly, on December 17th, the Sixth Circuit dissolved the stay. Did not see that coming. And I certainly was flat out wrong in things I was telling people, because I thought this thing was going to die on the vine because of this 6-month sunset essentially of all emergency temporary standards. In other words, OSHA only has the authority to do something for 6 months on an emergency basis. So all of a sudden, then on December 17th, this thing is back on, and the dates for compliance had, and I forget the exact original date because it's so many dates flying around, but the bottom line is OSHA had to respond and figure out, okay, now what do we do? So they set a date of yesterday, the 10th of January, as the date when employers would need to have essentially the vaccination rule in place. And then they actually have a little more time for the testing procedure. In other words, an employer right now could say, no, nobody who's unvaccinated can enter the workplace. And in February, it's actually February 9th, I think it is, we'll have a testing program in place. But in any event, bottom line is that all of this immediately produced a emergency petition for a stay, or emergency application for a stay, to the U.S. Supreme Court on December 17th, the same day that the stay was dissolved. And then that allegedly resulted in an oral argument on Friday of this week on the application for a stay, or Friday of last week. So we're waiting for a decision. It may be very soon, but as of right now, today, we are living under a regulatory regime where employers of more than 100 in the United States must have a mandatory vaccination requirement for their workplace, or an alternative in place that is compliant with this OSHA standard for routine testing. And this is just a slide that shows you what the legal standard is, or reminds you of that, which is that it has to be a situation that is presenting a grave danger to workers. And of all of the OSHA emergency temporary standards, they're very rare, that have been litigated and challenged, only one has ever been upheld. There have been 6 that have been litigated. You can see how rare they are, and only one has been upheld. Now, again, what's in front of the Supreme Court right now is simply a stay request, not on the merits of this thing. But of course, because the stay needs to, or there is an assessment of whether the plaintiffs who are asking for the stay have a likelihood of success on the merits, the granting of the stay will be a finding that they're likely to succeed on the merits. So if there is a stay granted, I think we can pretty much assume that this thing is dead on the vine. Now, again, I could be flat out wrong again, like I was before. Now, if the Supreme Court turns down the emergency stay and lets this go forward, that sounds like a pretty much letting it go, that this requirement will live out the rest of its natural life until the beginning of May, and then will expire automatically by law. What happens after that, we'll have to see. Right now, there's been so much attention to this that we don't know what's going to happen after that. I guess we're really getting pressed for time already. The second case is the Prop 12 case. And this is the California, essentially the pork portion of it, the banning of gestation crates and other confinement for sows is in fact, and for any type of swine, is in fact the issue here. Although cage-free eggs are part of Prop 12, that has not been legally challenged. As of right now, this Prop 12, I'm going to skip forward here. There we go. As of right now, this is the petition for cert is pending with the U.S. Supreme Court to decide whether they're going to take this Commerce Clause, Dormant Commerce Clause challenge to Proposition 12. If they decide to take it, then we will just have to wait until later this year and see what the outcome is going to be. However, of course, the provision, isn't it always the case, that's what caused such a furor in this particular circumstance. The California Prop 12 requirements are in effect now. So they've been in effect since January 1. So as of right now, California has a problem that there's a definite constriction of the pork supply, because production of pork in accordance or compliant with the California standards is certainly not widespread. One of the ways that California got around that, and they adapted to this no supply problem, is that they have essentially declared that any products, and this includes eggs, but also pork products, that are essentially in the supply chain now can continue to be sold in California because they were not because the prohibition on the confinement of the sow is only going forward, and these swine that contributed, or the pigs that contributed to these products, were raised in whatever way they were raised prior to the law being in effect. So that's legal product that can still get sold in California. And also, essentially, they have also gone on to say, if you read their guidance correctly, that essentially any pig that was born before December 31st of 2021 can essentially continue to be processed and raised in the way that it used to be. So now the interpretation that California is putting out there is that essentially it's only applicable to pigs that are born after December 31, 2021. So that's an interesting twist on this, and does alleviate sort of the, where's the bacon problem that California has been, getting a lot of press about. All right, I'm gonna keep going. Okay, Roundup. In the glyphosate litigation that I spoke of before, there is this selected case, the Hardeman case, that returned a $25 million verdict. It was actually higher, it was reduced. And that was selected by Monsanto/Bayer to be the case to be taken to the US Supreme Court, and claiming error in allowing the jury to consider a fair to warn products liability theory against Roundup and glyphosate containing products, because the federal registration of the pesticide is essentially, or the process in FIFRA for the federal registration is the equivalent of federal preemption. In other words, it is field preemption rather than express preemption, because there is no express preemption in this particular instance. In any event, that is pending before the Supreme Court. It's obviously going to have a huge effect on the billions of dollars worth of Roundup glyphosate liabilities that are pending against Monsanto/Bayer. And the last docket entry was that the Solicitor General was being asked to weigh in. And that was essentially because the impact of FIFRA in a lot of ways is being also considered and litigated and potentially impacted by this case. And no one is there to speak on behalf of the federal government with regard to the impact on federal law that any decision might have. So that's what's going on with that case. Now, the Sackett case is pending right now on a petition for cert, and this is the one that is essentially asking the Supreme Court to reconsider and essentially reshuffle the entire deck, going all the way back to 2006 in the Rapinos case. And again, you may recall that the plurality decision talked about continuous surface water connection to regulated bodies in order to be considered within the waters of the United States. And there was a concurring opinion from Justice Kennedy, I believe it was, that was talked about a significant nexus to a regulated water of the United States for some item of surface water to be considered to be within the waters of the United States. And essentially, the Sacketts want the significant nexus argument to be downplayed and to get a stricter continuous surface water connection type of interpretation. Significant nexus has become how EPA in having to deal with this plurality decision, they've had to, or they sort of had to pick their theory or pick their test, and they decided to really concentrate on the significant nexus test. And the Sacketts are basically saying, wait a minute, we want you to go all the way back to that and shuffle that deck again. So while we have a new Waters of the United States rule pending from the Biden administration, and that the Trump administration's navigable waters protection rule is out, we have this case that is basically saying, let's shuffle the whole deck and let's go all the way back to prior to the Rapinos case and start again. And that one again is just still pending. And the next one was the one that I told you about, which is the EPA's authority to allow the sale of gasoline with up to 15% ethanol in it, during the summer months. There we go. And essentially the Supreme Court decided yesterday that the EPA does not have the authority to allow E15 to be sold during the summer and periods like May 1 to September 15. So from now on, right now in the United States, E10 is the only legal or the highest ethanol content, let's say, that standard gasoline can be, for motor vehicles can be sold in. So we will no longer see any E15 pumps. Lastly, we have the Kansas ag statute. This one, and I have to go real quick here, but this one, it was just recently decided, and I forget what was it, the 10th Circuit decided in August that and this is the first interpretation of a ag statute that we had by a circuit court of appeals. Kansas decided to appeal that because they did not like the fact that the 10th Circuit had invalidated certain provisions of their ag statute. Don't like to use that word, but it is the word that is commonly used now. So I think we just have to give in to it. In any event, that is still pending. It would be helpful to have a little more case law. We have this 10th Circuit opinion now, which is the only federal circuit court decision on ag laws that's out there. So we'll see if the Supreme Court wants to take this up or not. Don't want to get into any more specifics than that with the time limitations. My PowerPoint will be available to you. And as you can see, I like to put a lot of information in the PowerPoint. So I think the PowerPoints are very helpful to have because I got links all over the place and all sorts of good background information. I'm going to stop sharing and try to take some questions.
Okay, do we have any questions? There were a couple that were submitted through the Q&A function that we've answered as they arose. Are there any additional questions that people want to enter, or I guess the easiest thing is to have you enter it in the Q&A. There is a function we can allow you to speak as well if anyone has a question that they want to ask verbally. Okay. Any questions? I'm not seeing it. Here we go. One in the Q&A. A question regarding the E15 denial of cert. Any idea how this might play out in ag country?
That's a good question. Obviously the response that has come from like the Corn Growers Association, everything has kind of been conciliatory. They have not wanted to sort of get out the big guns and go and flamethrower this thing. They've tried to just basically take a reasonably okay, we don't like it, but we'll move forward. And so that's and it's a lot like the RFS. Their response to the RFS standards that were announced by the Biden administration, I think, I think they're kind of, maybe I'm just going to speculate, but I think that they're seeing that perhaps it's not in their interest right now to come out guns blazing, when they get defeated in court, and to, just in the sense that the government is, making mandates for their benefit, and, doing things that, are, you can use whatever words you want. Are they getting special treatment by the federal government? Are they getting special concessions that others in other businesses don't get? Probably the answer is yes. And I think they kind of seem to be recognizing that it doesn't look so good, particularly when the administration that you have is about as favorable of an administration as you're going to get. And the EPA, maybe I should make sure I say this, the EPA is backing the Supreme Court's decision. They are, they in fact supported that position. They were opposing the ethanol industry's position in the on the petition for cert on the E15 rule. So, that's interesting, things going on with the EPA's position under Biden on ethanol. They're playing sort of both sides of the issue at times and trying to keep some kind of peace. Maybe that's the way to go.
Okay, thank you very much, Brooke. Thank you for the question. We'll go ahead and take a break. We'll reconvene at 2:15 Eastern time for our second session.